All attendees are in listen-only mode.
Hey, good afternoon. This is Byron King in Columbia, South Carolina Association of Realtors. It's July 25th, 2013. Michael Lee is going to be our presenter today on the seller disclosure. I'm going to do a quick kind of introduction on the thing. This is the seller disclosure going into effect August 1st. If you take a listing in July, then you would use one of the 2003 or the January 2013 seller disclosure form. Any seller disclosures for listings taken after August 1st or renewed after August 1st, you'd use the July 2013. And we wanted to go through a quick history and thank some of the realtors that worked long and hard on this project. It's about a 5-year project back 2008. Realtor Andy Walker out of Columbia and Peggy Gaines out of Columbia, both Janine Keys out of Orangeburg, worked on a joint SCR LLR task force that came up with a draft but was not approved in 2008. Back in 2011, the Central Carolina Realtor Association, their forms committee got on board with pushing for an update. That was chaired by Jennifer Harding, Brenda Hanna, attorney Gary Pickren, Marty Bedell, Mary Ellen Ramos, Sharon Cornelius, Shelby King, Sherry Meltropole, Susie Carlson, Tina Burgess, Trevor Woodleaf. SCR guy and got the band back together with Andy Walker, Peggy Gainey, and Janine Keys to work with those guys. And then commissioners Diana Brothers and Sarah Takis in 2011, in the fall of 2011, got the SC Real Estate Commission to put together a task force. Cox, Chair Hamlin O'Kelly out of Charleston, Jonathan Stackhouse out of Columbia, and upstate realtor Evelyn Young on the task force that worked for about a year. Public comment August 15th of September 15th of 2012, and then went ahead with the form in early January. And in February at the Real Estate Commission, we had some Columbia brokers, Lori and Jimmy Derrick, Eddie Wilder, Ron Rowe, Gary Pickren attended the hearing and then asked for some updates to the seller disclosure. So a task force was formed in February 2013 that met in the spring of 2013. Realtor Fritzy Barber of Greenville, Commissioner David Krigler out of Greenville, and again, the Commissioner Kelly was the chair, Commissioner Stackhouse was on there, and the other people serving on that, Morris Lyles, Margaret Ann Ashburn, Chet Smith, Robertson Allen, Sharon Young, Attorney Gary Pickren, LLR staff, both Tiller and Roderick Atkinson. The draft was introduced in April, posted online, and then in June was approved for implementation August 1. And this webinar is sponsored by REF and the annual conference. Go to screaltors.org for annual conference 2013. Turn over to Michael, and we'll be taking some poll questions. Thanks.
Thank you, Byron. I'd like to thank everyone here for joining us. And right now, I'm going to pull up my screen so you can all see the form that I have pulled up. I think we're good to go now. And I just want to quickly take you to the Real Estate Commission website here. The address for that is llr.state.sc.us/POL/REC. This is the page of the Real Estate Commission where you can find the form. Scrolling down to it, there's some other information here that you all might want to check out, but the two forms that I'm going to have pulled up and going through with you today is right here at the middle of the page. It says South Carolina Residential Property Condition Disclosure Statement. Effective date again is August 1st. That's coming up shortly. So all listings taken after that will require the new form that we're going to be going over. Below that is the South Carolina Residential Property Condition Disclosure Statement Addendum. That's a new feature for this version of the form. We're going to be going through that as well towards the end. A few of the big changes that were made by the task force that Byron kind of went through the history of that. One of the big changes is the AOA addendum. All of those questions which were kind of dispersed throughout the old version of the form have all been taken out into a separate addendum. That is what you see right here with my pointer. So if you'd like, you can pull those up, or you can follow along on my screen and as we go through it, and please ask questions if you have any. All right, so we're looking at the front page of the form. Again, this is the South Carolina Residential Property Condition Disclosure Statement. The front page is going to be similar to the old form that you're all accustomed to, but we're still going to go through it. The first paragraph addresses the statute that requires this form. The South Carolina Code of Laws, Title 27, Chapter 50, Article 1, requires that an owner of residential real property, single-family dwelling unit, or a single transaction involving transfer of 4 dwelling units or less shall provide to a purchaser this completed and signed disclosure statement prior to forming a real estate contract. This disclosure must be provided in connection with any sale, exchange, installment land sale, and lease with an option to purchase contract. This disclosure is not required in connection with transactions listed and exempted by South Carolina Code 275030. Again, that's the list of exemptions. If you pull up that statute, I think there's about 14 of those. And if you fall under one of those categories, then if the property owner falls under one of those categories, then they are exempt from filling out this disclosure. Moving right along, owners should answer the questions fully, honestly, and appropriately by attaching documents, checking a box for each checkbox question, and writing in the blanks on this disclosure statement. If a question is answered yes or asked for a description, then the owner must explain or describe the issue or attach a descriptive report from an engineer, contractor, pest control operator, expert, or public agency. If the owner attaches a report, owner shall not be liable for inaccurate or incomplete information in the report unless owner was grossly negligent in obtaining or transmitting the information. If owner fails to check yes or make a disclosure and owner knows there is a problem, the owner may be liable for making an intentional or negligent misrepresentation and may owe the purchaser actual damages, court costs, and attorney fees. If a question is answered no for any question, the owner is stating that the owner has no actual knowledge of any problem. Here I want to stop and highlight that that last sentence of that paragraph. The owner is stating that he has no actual knowledge of any problem. That's the burden of proof that's going to be argued over if there's ever an issue. Well, I think that we've been using in our presentation is if a property owner, I think one of the questions asks about roof leaks. The property owner states that no, he has no actual knowledge of any roof leaks. Subsequently, the buyer, the new owner of the home, discovers there is one, and wants to sue the seller, and regarding that issue, that's going to ultimately become a legal issue, and the burden of proof that the new buyer is going to have to prove is that the seller had actual knowledge of the problem and still didn't disclose it and marked no. At that point, again, it does become a legal issue, and both sides are going to have to argue their way, and then the call will be made by a court of law whether the property owner, seller at the time, had actual knowledge of the problem and didn't disclose it. Moving on to the next paragraph, if a question is answered no representation for any question, owner is stating that owner is making no representation regarding the conditions or characteristics of the property, but owner still may have a duty to disclose information that is known or should have been known. If a question is answered and subsequently new information is obtained, or something changes to render the owner's answers incorrect, inaccurate, or misleading, example, again, the roof begins to leak, owner must promptly correct the disclosure. In some situations, the owner may notify the purchaser of the correction. In some situation, the owner may correct or repair the issue. If the owner is assisted in the sale of property by a real estate licensee, the owner remains solely responsible for completing and delivering this disclosure statement to the purchaser. The real estate licensee must disclose material facts about the property if the real estate licensee knows or reasonably should have known about the issue, regardless of owner responses on this disclosure. Owner is solely responsible to complete this disclosure as truthfully and fully as possible. Owner and purchasers are solely responsible to consult with their attorneys regarding any disclosure issues. By signing below, owners acknowledge their duties and that failure to disclose known material information about the property may result in owner liability. Owner must provide the completed disclosure statement to the purchaser prior to the time the owner and purchaser sign a real estate contract unless the real estate contract states otherwise. Owner should provide a signed copy to the purchaser and keep a signed copy by the purchaser. A real estate contract, not this disclosure, controls what property transfers from owner to purchaser. Again, that's the first page that outlines all the requirements by the statute. Pretty straightforward, and also explains the answer choices that the property owner will be making as they fill out the form. From here, we're going to move ahead to the first page of the, or I guess the second page of the form, where it gets into the actual substantive questions. Hopefully you guys are all able to follow along. I'm going to jump in right to the top of page 2. Again, this is explains the answer choices and kind of the directions for the owner to fill out to answer each question. It says, apply this question below and the 3 answer choices to the numbered issues 1 through 14 on this disclosure. As owner, do you have any actual knowledge of any problems concerning? And problems we have here defined: problems, defects, malfunctions, damages, conditions, or characteristics. Oh, and as we go through the form, again, one of the other big changes that was made format-wise, all of you should probably notice right away that the form looks a lot different from the previous forms, and the way they're broken down, each section has a heading. It's going to be bold and in all caps, and those headings come straight from the statute. I think the task force really wanted to emphasize or make sure that the form adhered to the statute as much as possible. So that's where those headings come from, straight from the statute. They're broken down section by section, and that's how I'll be going through the form with each section, and then all the questions, the specific questions per section. So number 1, we have water supply and sanitary sewage disposal system. We have questions 1 through 4, and again, those are the checkbox questions. You'll notice the answer choices to the right of each page. Again, those are yes, no, and no representation. And the question that we're applying, again, goes to the top. Basically, you're applying the question, do you have any actual knowledge of any problems concerning? And then number 1, water supply. Number 2, water quality. Number 3, water pressure. And number 4, sanitary sewage disposal system for any wastewater. And then continuing with that same section, section 1, we have describe water supply. We have those choices, and hopefully, I know the task force tried to be exhaustive as possible whenever we have a question with any lists or choices. The most common ones that are available, and I guess there could be some unique situations, which there is the checkbox for other as well. So we have describe water supply, describe water disposal, and describe water pipes. That's section 1. We're going to continue to move down to section 2. We have roof, chimneys, floors, foundation, basement, and other structural components and modifications of these structural components. Moving down to question 5, again, the same question that you're applying. Do you have any actual knowledge of any problems concerning roof system? Yes, no, no representation. Number 6, gutter system. Number 7, foundation, slab, fireplaces, chimneys, wood stoves, floors, basement, windows, driveway, storm windows, doors, ceilings, interior walls, exterior walls, sheds, attached garage, carport, patio, deck, walkways, fencing, or other structural components, including modifications. And then below that, approximate year that current roof covering was installed or modified. There's a blank to answer that. Approximate year structure was built, and then during your ownership, describe any known roof system leaks and repairs. And that is section 2. We're going to move down to section 3. Again, we're on the bottom of page 2. Section 3 is plumbing, electrical, heating, cooling, and other mechanical systems. We have questions 8 through 14. Those are, again, the checkbox questions. Yes, no, no representation. Do you have any actual knowledge of any problems concerning plumbing system? Number 9, electrical system. Number 10, appliances. Number 11, built-in systems and fixtures. Number 12, mechanical systems. Number 3, heating systems. Number 14, cooling systems. Section 3, which is the current section that we're talking about, continues on the next page at the top, which we will pull up as well. Again, this pertains to plumbing, electrical, heating, cooling, and other mechanical systems. The question states, describe the cooling system, describe the heating system, describe HVAC power, and describe HVAC system approximate age and other HVAC systems. I think this question addresses the properties that have multiple HVAC systems on it, and this is the appropriate place for that question to be addressed and that disclosure to be made by the property owner. All right, that was section 3. We're moving on to section 4, present or past infestation of wood-destroying insects or organisms or dry rot or fungus, the damage from which has not been repaired. Question below, describe any known present wood problems caused by termites, insects, wood-destroying organisms, dry rot, or fungus. Describe any termite/pest treatment, coverage to property, name of provider, and termite bond. And then the last question for that section, describe any known present pest infestations. All right, we are on section 5 now, on page 3. Section 5 is the zoning laws, restrictive covenants, building codes, and other land use restrictions affecting the real property, any encroachments of the real property from or to adjacent real property, and notice from a governmental agency affecting this real property. We have some directions below that. Apply this question below and the 3 answer choices to the numbered issues, 15 through 23, on this disclosure. As owner, do you have any actual knowledge or notice concerning the following? 15, we have violations or variances of the following: zoning laws, restrictive covenants, building codes, permits, or other land use restrictions affecting the real property. Again, yes, no, no representation. 16, easements, party walls, shared private driveway, private roads, released mineral rights, encroachment from or to real property. Next, legal claims, foreclosures, bankruptcies, insurance, tax liens, other liens, insurance issues, or governmental actions that could affect title to the real property. 18, room additions or structural changes to the property during your ownership. Next, problems caused by fire, smoke, or water to the property during your ownership. Number 20, drainage, soil stability, atmosphere, or underground problems affecting the property. 21, erosion or erosion control affecting the property. 22, flood hazards, wetlands, or flood hazard designations affecting the property. And finally, on number 23, flood insurance covering the property. Below that, we're still in section 5. We have describe any green energy, recycling, sustainability, or disability features for the property. And then below that, B, describe any Department of Motor Vehicles titled manufactured housing on the property. All right, that is page 3. We are moving on to page 4 with the next section. I believe that is section 6. At the top, we have the heading, buried, unburied, or covered presence of the following: lead-based paint, lead hazards, asbestos, radon gas, methane gas, storage tanks, hazardous materials, toxic materials, or environmental contamination. The question asks, describe any known property environmental contamination problems from construction, repair, cleaning, furnishing, intrusion, operating, toxic mold, methamphetamine production, lead-based paint, lead hazards, asbestos, radon gas, methane gas, formaldehyde, corrosion-causing sheetrock, storage tanks, hazardous materials, toxic materials, environmental contamination, or other. Again, going back to kind of earlier directions, if the property owner doesn't have enough space to fill out all of their answers, they can attach additional sheets or any other report that they get from an expert, contractor, plumber, electrician, what have you. That's just another way to give them the most space to fill out their answers. Okay, section 7, below that, existence of a rental management, vacation rental, or other lease contract anticipated to be in place on the property at the time of closing. These questions are geared towards your property management situation, and the question states, describe the lease terms and any leasing problems. Next, state the name and contact information for any property management company involved. And below that, describe known outstanding charges owed by tenant for gas, electric, water, sewer, and garbage. That is section 7. Section 8, on the same page, the existence of a meter conservation charge as permitted by section 583750 that applies to electricity or natural gas service to the property. Question A, describe any utility company, finance, or lease property on the real property. Next, describe known delinquent charges for real properties, gas, electric, water, sewer, and garbage, your basic utilities. And then section 9, section 9, again, it gives some additional space for the property owner to explain any yes answers and attach any additional sheets or relevant documents as needed. That completes page 4. We're moving on to page 5 of the form. At the top of the page, the paragraph states, this disclosure does not limit the obligation of the purchaser to inspect the property and improvements which are the subject of the real estate contract. The purchaser is solely responsible for conducting their own off-site conditions and psychologically effective property inspections prior to entering a real estate contract. The real estate licensees, acting as listing or selling agents or other, have no duty to inspect the on-site or off-site conditions of the property and improvements. Purchasers should review all applicable documents, covenants, conditions, restrictions, bylaws, deeds, and similar documents prior to entering into any legal agreements, including any contract. The South Carolina Code of Laws describes the residential property condition disclosure statement requirement exemptions at 275010, which can be read online at the State House website, which is given right there on the form, and you can look up that statute and the exemptions below it and read as much as you need to follow that. Okay, we have current status of property or factors which may affect the closing, and that again is an answer choice for the current status of the property. And we have the other box as well, just in case for any unusual situations. And right below that, it states a residential property condition disclosure statement addendum is or is not completed and attached. This addendum should be attached if the property is subject to covenants, conditions, restrictions, bylaws, rules, or is a condominium. That addendum is going to be the last page that we go over coming up shortly. And if the property has any issues or is subject to any sort of homeowners association, then the addendum should be attached. Again, we're going to go over that in just a few seconds. The rest of the page is for the owner's signatures, and below that we have the directions for the purchaser, what the actual form means to the purchaser when they receive it, and space for the purchaser's signature. That is page 5. That concludes the main portion of the form, and we're going to be moving into the addendum. Scroll down here, and again, this is the South Carolina Residential Property Condition Disclosure Statement Addendum. Prior to signing contract, owner shall provide this disclosure addendum to the purchaser if the property is subject to a homeowners association, a property owners association, a condominium owners association, a horizontal property regime, or other similar organizations subject to covenants, conditions, restrictions, bylaws, or rules. Anytime you see that acronym CCRBR, that's what the acronym stands for. Again, covenants, conditions, restriction, bylaws, or rules. These organizations are referred to herein as an owner's association. Purchasers should review the applicable documents, the covenants, conditions, restrictions, bylaws, deeds, condominium master deed, and similar documents, all related association issues, and investigate the owner's association prior to entering into any legal agreements, including a contract. Owners association charges include any dues, fees, assessments, reserve charges, or any similar charges. Purchasers are solely responsible to determine what items are covered by the owners association charges. This addendum, again, puts a little bit more emphasis on the purchaser to find out and do a little bit of diligence on their part to find out what the HOA fees actually cover. If they are purchasing a subject, they can make a reasonable effort to find out those details, and that's what the addendum kind of highlights. It's up to the purchasers to review all the applicable documents, get the contact information for the HOA, and then find out all the details and what those fees actually cover. As we move below, we have the property address and describe owners association charges, and again the contact information for the owners association, so the purchaser can see that and do their research on their end. The questions below 1 through 11, we're gonna go through those right now. They're in the middle of the page of the addendum, and right here in the bold, you have the directions. Again, they're similar to the previous, the substantive part of the form that we just covered. As an owner, do you have any actual knowledge of answers to the following questions? Please check the appropriate box to answer the questions below. 1 through 11 are your standard checkbox questions. Again, those answer choices are yes, no, and no representation. Number 1, are there owners association charges or common area expenses? Next, are there any owners association or CCRBR resale or rental restrictions? Number 3, has the owners association levied any special assessments or similar charges? Next, do the CCRBR or condominium master deed or visitor rooms? Number 4, do the CCR or condominium master deed create animal restrictions? Next, does the property include assigned parking spaces, lockers, garages, or carports? Next, are keys, key fobs, or access codes required to access common or recreational areas? Number 8, will any membership other than the owners association transfer with the properties? Number 9, are there any known common area problems? Next, is the property or common area structures subject to the South Carolina Coastal Zone Management Act? And finally, number 11, is there a transfer fee levied to transfer the property? And then we're going to wrap up with, again, kind of the bold heading at the bottom of the page, explain any yes answers in the space below, and attach any additional sheets or relevant documents as needed. We have space for the owner's signature and the purchaser's signature, and that's the end of the addendum.
Hey, this is Byron. While Michael looks over some of the questions that came in, sometimes we get questions, why did the Real Estate Commission, LLR, fix what arguably wasn't broken from the 2003 form? Some of the issues we get a lot of times at the state association, we have realtors where buyers get into properties and are upset about major repairs that aren't disclosed. Some of those major repairs can include fire damage, major foundation repair, flood repairs, or even toxic mold repairs. And also some issues came up over the years since 2003 when LLR created the first form, bed bugs, some private road issues about maintenance, property taxes, especially with point of sale, private transfer fees became an issue, especially in areas like Hilton Head. And something that's affecting people right now is flood insurance. So any buyer agents out there with buyers looking at properties need to investigate flood insurance prior to entering into a contract. SCR has created a new flood insurance disclosure form that's on our website. Will be updated with zip forms along with the other residential forms. And the issue with that is NAR lobbied to get an extension of the flood insurance. Part of the Congress funding that was doing away with some of the federal subsidies. So we've heard reports of insurance increasing 4 or 5 times on the coast on some of these flood insurance properties. So the buyers need to investigate flood insurance costs. Do not rely on the current seller's flood insurance costs. In some areas, FEMA will be remapping, and so properties that were not in flood insurance areas are now inside flood insurance areas. So you need to make sure that you check on flood insurance. And that's not just a coastal issue. We've had reports of that happening even up in Lake Greenwood areas. And off-site conditions were a big issue. It's very difficult to address off-site conditions. So as Michael Lee was pointing out, our staff attorney, the LLR task force put a lot of emphasis on buyer agents and even buyers doing some legwork, doing their due diligence to investigate off-site conditions and to investigate psychological impacts. You know, if a property was subject, you know, where a murder happened or somebody says the house is haunted or something like that. And then in 2009, we had a court case that gives you absolute liability protection so long as you don't know that there's false or misleading information in the seller disclosure. That case is 2009 from South Carolina Court of Appeals, Chastain versus Hilton Bibble. Hard to say. But I can send you a copy of that case, email Byron at screaltors.org. And Michael's back to answer some questions.
All right. If you see a seller has not filled out the form accurately, what action should you take?
All right. The question asks if the form has not been completed or not been filled out accurately, what are some of the options that the agent has? I think in that case, you can always go back to the client and let them know that there are answers missing or that there's some sort of issue with the form moving forward, and you know, have them complete it. Again, Byron kind of touched on it a little bit, that the form should be viewed as a liability shield for all of the agents out there. As long as you present the form to your client and explain what it is, and explain, you know, what kind of role the form has in the transaction. As long as they understand that and fill it out completely, then you should be good to go. If for whatever reason they just choose not to complete it or fill it out accurately, that's going to have to be that issue is just going to have to be addressed with the other party, and maybe they can, you know, between the parties they can work something out, or you know, some other arrangement can be had. But as long as you are you know, open and honest with your client and kind of explain to them why the form is required, why it needs to be completed accurately, then I think as the agent, you know, that's kind of the role you have with the form.
Yeah, that's what I would do, Michael. If you have a seller that still refuses, then you've got some leverage. You've got the listing agreement that the seller has signed agreeing to fill it out completely. And you also have a duty to disclose material defects. So I think call the hotline if that issue comes up. But I think Michael gave you good advice to talk to the seller, let the seller know, hey, this protects you as well as me. Let's fill this thing out correctly.
Why is the HOA addendum not numbered?
You're talking about page number? I mean, it is one page. It's a standalone document. By number, I just want to, you know, the questions are numbered. The pages aren't numbered because there's one page. So the idea is you would just attach that to the seller disclosure. The reason it's an addendum is we had some complaints from, remember back, I said back in January, we had some Columbia brokers that came forward to the Real Estate Commission meeting. And then we took the Real Estate Commission took public comments during the spring of 2013. Some of the comments were, hey, I live in a rural area. There are no owners associations. This is confusing to my sellers. And it also helped us keep the forms shorter, so it was moved to an addendum, so it'd be more appropriate. If you had a property that has an owners association, you attach it. If you live in an area without an owners association, then you do not attach it.
All right. Oh, and just to touch on that a little bit, after what everything Byron said is accurate, I just think maybe since the main form is the main substantive part of the condition disclosure, which is numbered, We were kind of going through that, page 1 of 5, 2 of 5, and so forth. And I think the addendum, again, is just kind of a separate standalone page. If it was numbered, I'm assuming it would just say 1 of 1, and maybe that's why it was omitted. But the main page, again, is 5 pages, and then you have the separate addendum. The next question that we got asked, is the addendum used only when there is an HOA? I think that is the purpose of the addendum. That's why on the 5th page of the main substantive form, I'm going to scroll up. You guys will bear with me. In the middle of it, in bold, it asks if a residential property condition disclosure addendum is or is not completed and attached. Depending on the property that's subject to the form, if it's not subject to any HOA or doesn't have any of those issues, then the addendum would not be needed, and just the main form would be enough to satisfy the requirement. But if the property has any sort of HOA, and then it kind of describes the other kind of labels to a similar organization, if it's subject to anything like that, then the addendum is required and needed to be completed and attached to the main form.
I think it's a good answer Michael's talking about. I think another thing for buyer's agents that are listening today, it's very important for you to advise your client to investigate the owners association prior to getting a contract. One of the philosophies of the task force was to put a burden on the buyer and the buyer agent to do some due diligence on the HOA, the owners association, the landowners association, the condo owners association, horizontal property regime. We're getting calls about these owners associations having problems, especially with short sales and foreclosures and owners not paying their fees, that some of these owners associations are having financial problems. Also, there was a question on the January 2013 form that asked about lawsuits, and that question was omitted by the task force because they felt like, hey, it's up to the buyer agents to start investigating owners associations to find out if there's lawsuits or if they're paying some sort of settlement, or if there's some sort of financial problems with the owners association. So like Michael was talking about in that second paragraph on the addendum, purchasers should be reviewing all the documents for the owners associations, covenants, conditions, restrictions, bylaws, deeds, condo master deed, similar documents, related association issues, that's financial issues, maybe even investigating the owners association to find out how aggressive they are about enforcing rules. I mean, you've all heard these horror stories about these owners associations that enforce the rules so much that it becomes a burden to some of the property owners. So I think the philosophy of the task force, Michael talked about it, is to shift burden to the buyers and buyer agents to do some investigating on these owners associations.
All right, thank you, Byron. The next question that we've received asks, are new homes that have never been occupied exempt from the new seller disclosure? I believe that's kind of a that is one of the exemptions, I believe. If it's a brand new construction, and depending on who, and I have the list of exemptions pulled up if you want to look at that as well. Again, that's section 275030. I believe there are 13 exemptions. This one addresses, or falls under the category number 10, involving the first sale of a dwelling never inhabited. So if that is the situation, it is exempted from this seller disclosure. The only thing that I would like to say or point out is you kind of want to be careful with that. If it would only really apply to, again, kind of brand new construction. If it's ever been owned or kind of flipped, even though the time period might not be substantial, then in that case it would be subject to the property condition disclosure, and whoever the property owner is would be required to fill that out per the statute.
Michael, what about like an investor? Say I'm on to flip a house.
Yeah, we've had several questions about that, and even though, and the way the advice that we give is, no matter what the kind of the purpose behind the transaction is, if the owner views it solely as an investment or a business venture, they've never lived in the house, and they, like as Byron says, the question usually asks the client just is looking to flip the house. In that case, though the owner views the property commercial business opportunity, if the purpose of the property is residential and it falls under the category that's addressed by the statute, they would still need to fill that out. That exemption is completely different from the one we just talked about, number 10, involving the first sale of a dwelling never inhabited. It's a completely different situation. So as long as, again, the purpose of the property is residential and people will be buying, and the transaction will still involve that, the requirement still applies, and the property condition disclosure needs to be filled out by that property owner, despite them never having lived there, not really knowing the condition of the property. They still need to fill that out. All right. Next question. Which situations require notification of correction, and in which situations may the owner correct or repair?
Yeah, that's almost an individual one. You can almost go back question by question. So I think, because I came up with that same question too when I read LLR coming up with that. I think calling the hotline, legal hotline, you can talk to, we got 3 attorneys at South Carolina Association, our CEO, Nick Cremidas, Byron King, General Counsel, and Michael Lee, our new staff attorney, just joined, came on board. Phone number for that, 800-233-6381. And email, you just put our first names, Byron or Nick at screaltors.org. And we got 2 Michaels. Michael, what's your email?
My email is my name again, Michael, Michael, at screaltors.org. And just add on that, I guess that question kind of gets into, again, the substantive material of the, it may address a specific question. And the only thing that you want to avoid is getting into kind of advising your client on how they should answer a certain question, or how they should disclose something, in which situation. Again, the question specifically asks in which situation may the owner correct or repair, or just notify the potential buyer of the issue. So whenever it gets actually into the question, you kind of want to leave that up to the client. Again, your role as the agent is to explain the form, explain why it's required, what kind of role it plays in the transaction. But if anything specific to that question, or to a question in the form, it's really kind of up to the individual owner on what they want to do, how comfortable they feel with their options. And I think I touched on it a little bit earlier, that the form is really viewed as a liability shield for the agent, as long as, again, you're not really giving advice as to specific questions. You're kind of letting the property owner do his research and fill out the form accordingly.
Yeah, just kind of a quick to even answer, just flipping through the form. Anything that says during your ownership, I think, because that's all inclusive, I think you're going to have to update it and notify the purchaser. So that's looking at my forms. Section 2B talks about roof leaks. Section 518 talks about room additions or structural changes. The room additions, structural changes are really risky because it's hard to detect. Say adding a bedroom, and if somebody did it without a permit, the county might come in there and tell you to tear it down. Structural changes, that covers, that classic fire repair where we've had some issues. Pictures of people just, nailing 2x4s to charred rafters. So question 18 and question 19, problems caused by fire, smoke, or water to the property during your ownership. That's the classic flood repair, where somebody wants to know about flood or fire damage. So I think those are some quick answers.
All right, thank you for that question. Moving right along, next question asks, suppose the homeowner doesn't know the age of the roof. I think that's section 2. I'm gonna quickly try to scroll up so we can all take a look at that. But I think the best answer for that is the form. It's kind of, again, left up to the property owner to disclose as much as he or she would like, or as little. I mean, it's definitely advisable for everyone to disclose any known problems. But if that specific question, whether or the age of the roof, they don't know, they can explain. Again, that's why the answer choice at the end, it's kind of given throughout, where you can explain anything you want. They can include additional sheets of paper and address each specific issue that they have. If they don't know the age of the roof, they can just state, you know, not sure. You know, maybe kind of guesstimate around that, but then, you know, once they actually put a number, kind of explain this is the best estimate that we have. You know, again, if it was a checkbox question, maybe perhaps they could put no representation, but it's kind of one of those blanks where an owner reasonably should know the age of their roof. But supposing that they don't, they can always kind of explain why, and as long as they kind of make all the necessary disclosure and are completely open and honest about it, then I don't see a potential problem with that.
Yeah, that's a great answer. And this question's been on the forum since 2003, so we've not seen any court cases, or I've never gotten a legal hotline call. It's question 2 on the 2003 form about approximate age of roof covering. Kind of a heads up for buyer's agents, we have been getting calls about insurance companies driving by and looking at properties and saying, hey, that roof doesn't look so good. You need to get that roof replaced before we'll insure it. So just a heads up on that.
The next question is regards to section 5, number 16. Does party wall include a common wall and an attached townhome? And while we scroll down to that, I'm gonna go to section 5, that specific question, so we can take a look at it. The question asks, do you have actual knowledge, or the question in the form asks, do you have any actual knowledge or notice concerning the following? 16 is easements, party walls, shared private driveway, private roads, released mineral rights, or encroachments from or to adjacent real property. And again, the question asks, does party wall specifically include a common wall and an attached townhome?
Yeah, I would say so. I think party wall, is there an issue? You know, is there a problem with the owners arguing about who's got to maintain it or pay some charge? You know, buyers walking into that, they want to know about that. And this is a good question. I'm glad you asked about this question. This is the one question that you should always see answered yes on this thing. If you see it answered no, that's a red flag to you, because almost every property has utility easements. And that's actually a court case that went up to the Court of Appeals down in Charleston. The listing agent was on site. He's doing a favor for the buyer agent, letting the buyer on the property. The buyer was in the backyard and just kind of offhanded made a comment, hey, are there any utility easements on this property? And I'm sure the listing broker was thinking, hey, access, you know, driveway, somebody driving across the backyard, so they said no. And it was after purchase, they went to build a pool in the backyard and found out there was a 4-inch sewer line running through the backyard, prevented the pool construction, and sued everybody. The realtor tried to defend themselves. Court basically said, hey, you made a misrepresentation. It was reasonable to rely upon it. They were damaged, and we've added some defense features to that into the new contract. New contract is on our website, new residential purchase agreement, and we'll be going into zip forms in July.
Yeah, thank you, Byron. Just one last kind of comment that I think I have is, again, that heading for section 5 that comes straight from the statute asks or addresses any encroachments of the real property from or to adjacent real property. I think that just kind of covers a big group of things, and specifically whether in number 16 with the party walls, does that include a shared wall in townhome? I think that's what that whole section is trying to address and get at, is whether does the current property have any issues with anything that any kind of outside influence that it would have on the property, and if there are any issues with that, you should mark yes. And again, kind of explain the answer to that, and everything that Byron just explained kind of applies as well. All right. We're going to move along, continue with our questions here. The next question asks, what is a meter conservation charge?
Yeah, I actually had to look this up when because the task force, like Michael stated, task force wanted to lay this out in its section 8 for the people that are following along on your website. The LLR task force, they wanted to follow the statute, reorganize, and this was one of the things buried in the statute. I had to look it up. I'd heard of it when I figured out what they were talking about, but it's like here in Columbia, we're under SCE&G, and so they got, they want you to conserve energy, so they want you to put a new water heater, a new air conditioner heater in that saves some electricity. That's a big upfront cost. So they actually, SCNG can finance that into your power bill, and you pay over time to help you upgrade your energy conservation items in your home. And then it's financed through the power bill. So that's something that, a buyer would probably want to know about before they bought that house.
All right. The next question asks, or kind of makes a statement first and then asks a question. It says, during your ownership, describe any problems. And I guess we've seen that in a couple places throughout the form. And the question specifically asks, could this not be added to the bottom of each section? I'm not sure if this has been discussed, but what was the reason for not asking about previous issues for each sections? I guess you could throw that in below every section and kind of give the owner to explain everything. I think it really the main reason is just format-wise. You want to keep if we did that, the form would just be extremely long, very difficult to fill out. I think for the client, they would have that would kind of open up the flood bank, so to speak, as far as questions. What should I put for this? Do I include this? Do I not include that? I think the form does a fairly good job of kind of breaking down each section, and each question is very specific. So it should touch on all the big issues and give the property owner an option to, or the opportunity to disclose any issues with it, again, with the checkboxes, yes, no representation, and other questions that ask you to describe any known problems. So I think that's why that kind of open-ended question isn't asked for each section. It's just a little too open-ended, and there's no really that I don't think that detailedness is really needed, or what the purpose behind the form.
Yeah, and I would even add, and believe you me, every sentence, every comma, every period on this document's been argued about by these task force over the last 5 years, and there's always a philosophy, between the people that are on the task force at LLR. The buyer agents want more information, listing agents want, maybe less information to expose their seller to less problems. Because you got to remember, you always got that situation where you've got an 80-year-old person living in a house, been there, for 50 years. They may not remember stuff from a long time ago, so that's an issue they had to deal with. And really, the idea of the General Assembly when they passed this was, hey, what are some real problems with the property right now? And some of these during your ownership really address some of the big ticket items that came up, questions over the years. We talked about them. That was one reason, the repair question was put on there that created some concerns about, hey, that repair question is going to make us have to get too detailed about repairs. But they were always asked after major repairs. Hey, there's a fire in the house and you made repairs to the rafters. Buyers want to know about that. There's a roof leak, because that can create all kinds of issues, wood rot, termites. So in section 2A, when it talks about B, during your ownership, describe any roof system leaks and repairs, because that can be so expensive and create mold or termite issues or wood damage. That's an important question that the task force felt should extend beyond just present conditions. And then over on section 5, that hits the other two major issues, room repairs or structural changes to the property during your ownership. That really hits that, somebody did some major foundation repair. That's something that buyers really want to know about. We've had some problems with in the past. In 19, caused by fire, smoke, or water to the property during your ownership. We talked about that Chastain versus Hilton-Bibble case in 2009. That was a flood problem in a property. Of course, the buyer sued everybody. Seller actually said, yes, there's been flood issues, and then the court basically went on to say, hey, because the realtor was being sued, you can't sue the realtor because it was a seller's disclosure, and the realtor had no duty to investigate property conditions, did not have any reason to know that anything on the property was falsely or misleadingly filled out. So 18, 19, and then in section 2, so you got roof leak, structural changes. So roof is the roof, structural changes at the foundation, and fire, smoke, or water kind of covers the the big problems we've had with sellers making major repairs on fire or on water damage, and buyers want to know that.
All right. The next question asks, should the seller leave some blank? I'm assuming that refers to questions, leave some questions blank if they do not apply and whether that could be because he doesn't have the information or what have you. Should the seller leave any questions blank? And I think the answer to that question is basically no. They shouldn't leave any question just completely unanswered. I think that that one doesn't complete the form, so you have issues with that. And then if that unfinished or incomplete form is given to the buyer, the potential buyer, then they're just kind of gonna look at the blank and not really know what the seller is trying to say. If it's a checkbox question, I think an option for that seller, for whatever reason, if the question doesn't apply, then they can put no representation. And then again, this is just completely up to the property owner. So if they want to disclose anything or explain any other answers, they can again do that at the end of the form in the blank spaces provided, or attach any additional sheets that's required or that's applicable to explain their situation. So if there's, again, for whatever reason they don't feel comfortable saying yes or no to a question, it doesn't apply, and then they check no representation, again, they can just kind of explain why they feel like it doesn't apply, why they mark no representation. And as long as the whole form is completed, then I think you're in the clear. That just emphasize, don't try not to leave any blanks unanswered, because again, then the form is not completed and the buyer has no idea what you're trying to represent.
Yeah, I think that's a good answer, because keep in mind, any no representation or yes, or even a blank answer, even worse, is going to be a huge red flag for buyers and buyer agents. So buyer agents, if you see a no representation or a yes answer or a blank answer, even more scary, you need to really inform your buyer, hey, we really need to investigate this on our own. It's a huge red flag. And the hammer is on all this stuff, if a seller doesn't fill this thing out correctly, leave something blank, and then they get second guessed, the statute allows the buyer to sue for actual damages plus court costs plus attorney's fees, which could, you could have a $500 issue, but the seller loses, they pay the $500, then they got to pay, court costs, another, $500, and then attorney's fees of $5,000.
So basically, blanks should not be left alone or just kind of not addressed. Everything should be at least filled out and explained. I think that's the best approach to it. Next question asks, what do we do if the covenants are too voluminous to attach? I guess meaning it's just they pulled all the necessary documents, whether it's a HOA, master deed, or the acronym that we described earlier, CCRBR, the covenants, conditions, restriction, bylaws, or rules. This going back to, again, the property condition disclosure addendum, specifically with HOA issues. And if the property owner or the seller pulls that and wants to attach that to this disclosure and the addendum to kind of give the buyer a heads up and give them all the information, all the details that they would like regarding the HOA, and it's just too large to do that. Again, this kind of going back to an earlier point, it kind of puts the purchaser, it puts the responsibility on the purchaser to do a little bit of research. So as long as I feel like the addendum's filled out and it gives a place to for the contact information for the homeowners association, as long as you put that, maybe attach an additional sheet of paper stating that you try to attach all the documents, but it's just way too much. It's just cumbersome. So as long as you contact the person at the owners association, have them pull it up for you, send it to you, or these days a lot of those things are online. So as long as the purchaser contacts the owners association, gets the access to that, and they can just pull it up on their own computers or what have you, and kind of read through that. So I don't think there's a kind of a hard requirement for the seller or the property owner to attach that, especially if it's as voluminous as some of those documents could be. As long as you kind of make it available for the purchaser to do that, and the purchaser again has the responsibility to research it and find out any issues that the potential property has.
Yeah, and if you need help doing that, like Michael says, putting it online, we've got a tech helpline as a new member benefit. You can contact them and they can help you with that.
All right. The next question asks about question 6 on the addendum. So I'm going to scroll down to that so we can all take a look at it. And the question asks, on single family homes, would you check yes if there is a garage?
Yeah, I would. It's asking, does the property include a garage?
Yeah, absolutely. Yeah, the question specifically asks, does the property include assigned parking spaces, lockers, garages, or carports? And again, this is the HOA addendum. So as long as the property, even if it's a single family house or whatever it may be, as long as it's subject to an HOA, you're going to use the addendum again. And since the question asks about garages specifically, and if there is a garage attached to the property or included with the transfer, then that's what the question, I think, is addressing, and you would mark yes.
I think it was intended for, like, you got a big condo unit, say at the beach, and there's a separate garage somewhere, but that's a good point. And keep in mind, a lot of these questions, you're worried about lawsuits, so a single family with a garage, only a buyer is going to be able to look at that and see it, so I doubt you would be sued even if you were to put a no or no representation. Did we do any poll questions? We don't do any poll questions. Okay, we'll do those at another webinar.
All right, moving along. How do we find the answer to number 10 on the addendum page? And number 10, we have it pulled up. Right here, we're going to scroll down. Is the question 10 on the addendum asks, is the property or common area structure subject to the South Carolina Coastal Zone Management Act?
Yeah, what I tell people when they call this is the grandfathered property built inside the setback line. You really need to do a survey to determine that. So, the seller could inquire about it, try to find out. But if it's not on the beach, I mean, obviously it's not going to be impacted by that. This is the structure that was built prior to the setback line. If it has damage in a hurricane, you cannot rebuild. So that's what it's designed to find out. But buyer agents, you always want to make sure that your buyers are getting surveys. One for this issue, and also isolated wetlands. If they may want to build a swimming pool or a workshop or a garage, a detached garage, without that survey on isolated wetlands, they may be mad at you for not recommending that you get a survey. And we've tried to add that to some of our forms. Hey, always get a survey. And wetlands don't always have to be wet. The biologist, can come out and say, hey, during the rainy season, certain vegetation grows here. This is an isolated wetland. You can't build.
Yeah, I think that's the best approach to it. That the specific question 10 again asks about the Coastal Zone Management Act. You're going to mostly deal with that again along the coastal regions of our state, down at the beach, and again has to do with those setback lines and whether the property in any way encroaches that, and that's kind of the main issue there to address. Yes, no representation, and to find that out, to find out more information about that, you definitely want to get a survey done and see if that applies, and then answer the question accordingly. The next question, when will the new form be uploaded onto zip forms?
Yeah, what we've been telling people is the government can actually mandate this form. This is unlike our SC Realtors residential and commercial forms where we say, hey, these forms are member benefit, you can use them. This form is actually a government form, so it's not SC Realtors form. This is from the Labor License Regulation Agency, South Carolina Real Estate Commission, and they have said, thou shalt use this form for any listing taken or renewed after August 1st. So to prevent confusion, Zip Forms is loading it in July, so it should be online August 1st. We don't want to put it on there too soon to confuse people. And Michael, we were talking before the presentation, he had a call where somebody had used one of these things too soon, so that's why it's not on there yet.
Yeah, just to touch on that a little bit, I think the form, again, it is promulgated by the Real Estate Commission, by the Department of Labor here in South Carolina, which is a state agency. Our legal staff has had some input and kind of helping design and format it, but all of the substantive material, all the questions, all the wording, the checkboxes, the answer choices, the explanations, the directions, that all comes from the Real Estate Commission. And since it's essentially their form, and they put the effective date as August 1st, we didn't want to again confuse people, have it available on our website before August 1st and have people use it prematurely. So again, once we kind of get the go-ahead from the Real Estate Commission, I think we're going to work on that and getting up on zip forms as soon as that's available and appropriate. And from then on, again, after August 1st, the new form will be used. We're going to keep moving along with the questions. How does the owner complete addendum if the HOA has never been created or is currently inactive?
Well, this is stuff the lawyers do. I would, like Michael says, you try to answer as best you can and explain what's going on with it. That one, I mean, I guess it'd be hard to second guess somebody put a no there, but I would probably explain it just like you did in your question. If you check no, or you could put, in the explanation, the HOA has become inactive or has never been created.
Yeah, depending on what the situation is, if the property is subject to an HOA but yet has not been created or is currently inactive, maybe that means that it's unneeded, and the addendum is not required, and you can just fill out the main form and then again kind of explain why the HOA addendum is not attached, why it's not required, and you can kind of explain the situation. And if the property owner or if the potential buyer at that point, again, one of the main kind of highlights that we want to emphasize is that it puts a lot of the responsibility on the purchaser. So maybe they can find out and do a little bit of research on their end why it's been inactive, and whether there's still issues with that, and then they can kind of find out a little bit more, and then they're a little bit more informed as to deciding whether they want to move forward with the transaction. Next question: what does the question water quality mean? That is back on section 1, and I'm going to scroll up to it so we can all take a look at it. I believe it's question 2 under section 1, water supply and sanitary sewage disposal system. And the owner is supposed to mark yes, no, no representation as to the water quality.
Yeah, so like Michael was talking about at the beginning, you got to look up the question at the top. It says, as owner, do you have actual knowledge of any problem concerning water quality? So the classic example I use is out in Lexington County. It's probably been a while now, but it seems like yesterday. There was some industrial waste poured down, and everybody's out on wells out there, so it got down into the aquifer, this toxic material, and there's actually a plume through the aquifer where DHEC has tracked cancer patients coming out of those homes that were on those wells. Buyer agents, you always want to say, hey, buyers, you need to get water inspected if that's an issue to you. Buyer agents, you want to say get everything inspected. Let the buyer decide, hey, I want to save some money. I'm not going to get the water inspected or whatever they want to save money on. But you do not want to be the person like, don't worry about it, because if an issue comes up post-closing, they're going to come back at you, buyer's agents.
Yeah, that nothing really too much to add or substantial to add to that. I think that's a great example to use or to think about as we work with this form. Again, you apply the question at the top or the directions at the top. As the owner, do you have any actual knowledge of any problems? So anything that they feel like is an issue or could be a potential issue with the water quality, again, they can mark. It's kind of up to them. They can mark yes or no, maybe even no representation, and then kind of explain why. And the buyer at least is informed of that. The property owner, the seller, has disclosed what they know, again, actual knowledge. And moving forward with the transaction, as long as that's been disclosed, and again with the whole burden of proof being actual knowledge, just disclosing any potential issues that the property owner has knowledge of, I think is pretty safe. And that kind of question, the water quality, again, refers to that, and just kind of think of those examples and make all the necessary disclosures. All right, the next question: where is the information on areas that were not in floodplain but have been rezoned as in a floodplain area? I think this question is addressed in one of the sections below. I think section 5, we're going to move down to it, and I will point to the specific questions that we can look at. I think it addresses question 22. Again, we're applying the directions up at the top. As the owner, do you have any actual knowledge or notice concerning? And then 22, flood hazard, wetlands, or flood hazard designations affecting the property. And then even below that, question 23, flood insurance covering the property. I know Byron touched on it a little bit earlier in our presentation about all of these changes and upheaval that we've seen concerning flood insurance. So the question, our webinar participants question asks, where does the question that addressed these floodplains and the rezoning, FEMA's rezoning all of their flood maps, how does it apply? These two questions concern that, and then again, if there are any issues with that, the property owner would mark yes, and then they're able to kind of explain what what they know on their end. But again, the theme, one of the overriding themes of this is the responsibility of the purchaser. So as long as the seller discloses what they know and kind of explains everything that they have in regards to the flood insurance or the flood plains, the mapping, it's kind of up to the purchaser at that point to do their due diligence, specifically with flood insurance, find out if they buy the property, what kind of flood insurance premiums they're going to be subject to. Again, so many changes going on with that. So they're, again, can do a little bit of research, find out, contact some different insurance companies, again, find out as much as possible they can about the property, and then kind of once they know all of the information regarding flood insurance and the flood issues, they can kind of move forward with whatever they feel comfortable.
Yeah, and these webinars are archived, so we've got a flood expert, remediation expert as one of the archived webinars that if you live in an area, at the coast or near rivers or creeks or lakes, as FEMA remaps these things, definitely watch that webinar with Miss Jones, because she's a consultant that can consult with a buyer and talk about ways to minimize flood insurance costs. We've even had some calls from Hilton Head where it's cheaper to raise the property than to pay some of these flood insurance rates. So this is a huge issue, and we've got that new flood insurance disclosure that's going on to our website. Right below it, while we're here, look at that question A. I thought this was pretty neat. A lot of these questions are always negative. This is actually a positive, where you get to brag about the property a little bit for you listing agents and sellers. It's about green energy, recycling, sustainability, or disability features in the property. We met with appraisers in the upstate about 6 months ago, and they asked for realtors to start adding some of this information on the MLS sheet so they can incorporate it into their appraisals.
All right. One of the questions, or the next question that we're going to try to address for you is, if the problem has been repaired, i.e., for example, a new roof, do you disclose previous leaks in the roof? I'm going to move up again to the section where the roof leaks or the roof, chimneys, floors, all of that issues are addressed. We're up to section 2 again, if you guys are all following along. And we have a couple checkbox questions at the top. Describe any known problems with the roof system, the gutter system, and then below it asks approximate year that the current roof was installed or modified, and then below that B, during your ownership, describe any known roof system leaks and repairs. The first thing that I would probably like to comment on is again, this kind of question. If you get this question as the agent, again, it kind of goes to the substantive material of the form. That responsibility is ultimately on the property owner. You can kind of explain what the question, why the question's in there, or what the question addresses, and then kind of let them figure out how much or how little they want to disclose. The best advice that I guess I could give is, even if the new roof, if the roof has been repaired with a new roof and there aren't any known problems, the specific question asked right here with B, during your ownership, describe any known roof system leaks and repairs. So if there were any problems prior to the roof being repaired, maybe probably the safest way to go is to just disclose that, say there was a known roof leak at this time, but it has been addressed, it has been repaired, and that explanation should be enough. And then once you move forward with the transaction, if the purchaser is comfortable with that, then they're obviously going to do some inspections, or the home inspections on their end, moving forward with the transaction. I don't think any reasonable buyer is just going to take the seller's word for it, and whatever is just described on this disclosure, they're just going to go with that. They're still going to do the traditional kind of home inspections and figure everything out. But getting back to the specific question, even if something has been repaired and there's no new kind of issues, then then that's kind of the ideal situation. You just kind of disclose whatever problems there were, and then even further explain that it's been fixed, and that should kind of satisfy both parties, I feel like.
Yeah, and I think Michael just said the most important thing in this whole presentation. I want to repeat it so everybody understands where we're coming from. When you start, and I understand we're asking questions for general information, but Michael made a point that I really want to emphasize. If the seller starts asking you detailed questions about how to answer these seller disclosures, remember the one reason that you really want this thing filled out is your liability limitation. So I think under your ethics and your license law duties, you have an ethical duty to refer them to their attorney. It says on the front page of the form, any questions the seller should ask their attorney. And I think if you do start answering substantive questions, you can lose your liability protection. Here's why. Some of the language in that 2009 case, the Chastain versus Hilton Biddle, I can't say that word, but it talks about that the buyer would have to prove that the realtor knew that the seller had made false, incomplete, misleading answers, or answers that are inaccurate, incomplete. So the more you get involved helping them to answer these questions, all of a sudden that could be evidence the buyer uses against you to say, hey, here's evidence, here's an email, here's a conversation that the seller's talking about where the realtor told me how to fill this thing out. So always call the legal hotline, 800-233-6381 when you get these specific questions in real life. And I understand today we're asking questions to learn. That's great. But just keep in mind, Article 13, you have a legal duty, an ethical duty to refer your clients to attorneys when their needs required. And like Michael read on page 1 of this form from LLR, it says that the parties have a responsibility to talk to their attorney for any questions.
All right, thank you for that. And the next question refers to the HOA addendum again, question number 3. So I'm going to scroll down to that so we can all take a look at it. All right, here we go. And the question on the form asks, has the Owners Association levied any special assessments or similar charges? And then our webinar participants question wants to clarify, does the question ask, has the Owners Association ever levied any assessments, or do you mean any current assessments? Well, first of all, the form kind of asks the question again, has the Owners Association levied any special assessments or charges? I think that kind of refers to the past tense, because again, levied any special assessment is kind of presenting kind of past issues, anything that needs to be disclosed, any ongoing or any lingering issues from the previous special assessment or similar charges that the new property owner could be subject to. I think that's what the question is getting at. As far as the current assessments, I think that'll be addressed near the top, above that at the form. Describe the Owners Association charges, whatever the current fees are for the HOA, and what the new property owner would be looking at to pay once they purchase the property. Yeah, so I think the question 3 kind of addresses previous issues and whether it has any lingering effects, and then any current assessments, or don't really want to mix up the issues and use assessment twice, but whatever the current HOA fees are, then it's kind of addressed at the top. Everyone kind of knows about it. The seller makes a disclosure. The purchaser can find out exactly what those dues cover, and then that's kind of the 2 separate issues.
Yeah, I think Michael's right. If you look at all those questions 1 through 11 at the verb tense, very first verb in each sentence, they're all present tense except number 3, has. I think the intent was probably, buyers, when's a lawsuit going to happen? When they get hammered by a special assessment or similar charge. But, just thinking about it, I think that was an excellent question. The history could reveal, hey, that lets you know, say there was 10 years ago, there was some sort of a EFA stucco lawsuit as a special assessment. That might be something a buyer might want to know in case that issue pops up again in the future. So I think the past tense is a good verb tense to use there, because it shows you some issues that a buyer might be interested in, even though it was in the past.
And kind of a follow-up to that question, maybe from the same participant, is regarding that question 3 again on the addendum. Does this refer only to the term of the current owner's knowledge, or ownership period. And they just want to highlight that it's not specified on this document. I'm assuming that the addendum, that this is relative to the ownership period of the seller. I think, yeah, whether, I know some questions specify, during your ownership, do you have any knowledge or knowledge of problems concerning X, Y, and Z? Again, kind of the overlapping theme or the purpose of the form is, again, kind of what we talked about earlier, is actual knowledge. So the owner, whether it's during their property owner, if the question doesn't specify during your property ownership, it could include, all substantive knowledge that they had. So the issue with number 3, again, has the owners association levied any special assessments or similar charges? Perhaps those special assessments were levied, during the property owner's ownership, so they know, exactly what happened and have all the information on that and can disclose that, or whether it happened prior to their ownership, but it still had a lingering effect during their ownership and they still know a little bit about it. Again, whatever actual knowledge that they have and they can kind of foresee that being an issue, the safest way to go is to just kind of disclose that, explain that, and depending on, how comfortable the new purchaser feels with that, they can kind of accept it and move forward with the transaction, or again, kind of, maybe do a little bit of research on there and find out what exactly those special assessments were, why they are lingering, if they purchase the property, whether it's going to affect them, and then once they have all the kind of the relative information or the necessary information, they can kind of make a decision at that point. Thank you for that question and the follow-up. We're going to keep moving along. The next question asks, if a property is withdrawn from the market and then re-entered as a new listing following August 1st, but the listing agreement has not changed, does the seller have to fill out this new form?
I would say yes.
Yeah, I think so as well. I guess if the listing was taken prior to August 1st, you have the old property condition disclosure on file, but again, if the property has been withdrawn from the market and then re-entered with a new listing prior or after the effective date of August 1st, then you would kind of need to refresh that property condition disclosure. And since the new form at that point would apply, you would absolutely need to have the client fill that out, maybe, and then kind of update all the information that you have with the property moving forward, since you are going to relist it and it's going to be reintroduced to the market.
Yeah, keep in mind the reason LLR did this, they approved this form June 12th, 2013, and they recognize there's 40,000, 50,000 listings across the state of South Carolina. So that's why there's kind of this kind of soft implementation, so that the realtors weren't out there trying to get 50,000 documents signed over the summer. And like Michael explained, after August 1, if you're renewing or taking a new listing, then you put in.
The next question is kind of a similar question to the previous one. If we already have the previous seller disclosure on MLS, does a homeowner have to fill out this new one?
I would say no. The LLR, like I said, their philosophy was, hey, there's 50,000 listings out there. And if you remember back in December, they actually had to have an emergency meeting because they passed it right before Thanksgiving. So you had Thanksgiving and Christmas, and then they wanted you to have the new forms on 50,000 listings January 1st. And they realized, hey, that was an extraordinary burden on the realtors. They had the emergency meeting and gave that kind of soft grandfathering where you could use the 2003 or 2013 January form. Same idea here is you take a listing, if you've already got one on there like this question is, or you take one today or tomorrow, anytime up to August 1st, use the either the 2003 or the 2013 January form. August 1st if you renew or take a new listing, and you use the July 2013 songs.
Yeah, I think that's a kind of an ideal contrast to the previous question that we just had. The second question asks, or I'm assuming, it's already, the property's already been listed. The agent's taken the listing for the property. It's been on MLS. That's why the kind of the previous form, version of the form is attached to it. As long as it's not taken back off and it's relisted with a new listing agreement after the effective date of August 1st, which was kind of the previous question that was asked of us. That's kind of the opposite, or the contrasting situations, where the first situation you would need to have the client fill out a new form after the effective date of August 1st, re-update your listing and all the documents that go along with that, And then the second question, if it's already been, the listing's already been taken prior to August 1st, and the only thing that's changed is the effective date has come and gone. You don't really need to go back and kind of update right or kind of preemptively, as long as it's not kind of relisted and reintroduced to the market again. Hopefully that was a clarification and a good kind of polar examples as to which situation that you want to go into. The next question is, what is the process for updating the seller's disclosure for an active listing? For example, when a roof is replaced, an HVAC is replaced, etc. Can we list the updates in the agent remarks in MLS?
Yeah, I would say yeah, but I mean, keep in mind you're talking to two lawyers here, Michael Lee and Byron King. So because there's initials on the form, the safest thing would be to redo that. We talked about what he's talking about, the roof and the HVAC. So that's all on page 2 of 5. So you could actually, replace page 2 of 5 in the seller disclosure. You could put, roof system. If it was a leak, then you check yes. You could check no, and then you could say see explanation. So you probably swap out page 5 too. Or maybe attach a new page 5, or correction, 4 or 5 has the explanation section. Attach that or attach another document. Certainly you could put in agent remarks, but from a lawyer point of view, I would never want the buyer to be able to argue they never, you never told them that. But the reality is, if you replace something, it's going to be hard for a buyer to be suing you. A lot of this is based on when's a lawsuit going to happen. I guess if you replace the HVAC and the thing was some sort of system that had some problems and they tried to sue you but you didn't disclose it, you open the door for somebody to get attorney's fees. Is the danger of not doing this thing on a form and getting initials. Michael, what you think?
Yeah, for sure. Since the current form that we're talking about is kind of the big issue here, and the document it's the actual document that's kind of going to be driving the transaction, is going to be part of the transaction moving forward. If any changes like that are being made, I think that is the safest way to go. Either redo the entire form if there are several changes throughout, or as Byron mentioned, both of those issues happen to be on the same page 2. Maybe you redo that, let the client refill out all of the same answers to the previous form, but then whatever changes are made, if there was a known problem, they mark yes, now they mark no, and then kind of further explain that the repairs have been made. I think that's kind of, again, that's kind of the ideal situation is if there was a problem and it's been fixed, then the buyer, as long as that's disclosed and the buyer knows that, that's going to make them, I feel like, even more comfortable with the property moving forward. So yeah, and kind of another big theme that we have, or that the form has had, is kind of clarity, and hopefully with the format changes and the wording of the questions, it's pretty straightforward for the client to fill out. So as long as you, again, the agent, kind of gives the form out, in this specific situation, some things have changed, kind of explain, oh, I know that you replaced the roof because there were some repairs that needed to be made, or an HVAC system was replaced. You put that there were some issues with it on the previous form. Let's just update the whole thing, kind of clean it up, and have a new form out there with everything disclosed, and that kind of is good. It's a win-win for both parties, I feel like. Okay, the next question. Should the disclosure addendum be used when there are non-mandatory associations, and they have in the parentheses garden clubs, etc., that maintain common areas?
That's kind of, you guys are playing Stump the Lawyers. That's kind of a new one. I don't remember the task force talking about those. I'm assuming there would be some sort of cost. Maybe the garden club, ask you for a donation, or there's some sort of mandatory assessment, because that's when you're going to get sued. Or maybe they think the assessment's covering a common area, and then this garden club dissolves, and all of a sudden you got the front entrance looking really bad, where you got a buyer that's upset. So, you're talking to lawyers, so disclosure always protects the seller from getting sued, and protects the realtors getting sued. So I would use it and disclose it.
Yeah, definitely. That is a kind of a unique situation. I haven't heard anything about that specifically. Certain clubs, such as a garden club, that charge a common area fee, but it's not really an HOA and an HOA doesn't apply to the property, I think, the safest route to go with that is perhaps just kind of fill out the main form again, without the addendum, or because and then at the end of that, the regular form, the substantive form, you have some space there to explain anything you want, and then again, the property owner can attach whatever they want, and maybe they kind of explain, hey, there's no HOA associated with the property, that's why the addendum is not included. All of the questions that the addendum asks doesn't apply because there is no HOA yet. There is this other kind of club that the property is associated with that charges a fee. I, as the property owner, currently pay the fee. This is what it covers as far as I know, and then again, kind of give all the information that the property owner knows about that, and maybe attach some information about that particular entity. That way, the property owner again is made known, the purchaser is made aware of that. They can kind of do a little bit of research and find out exactly why or what that club or entity, what kind of relationship that they have with the property owner. So again, as Byron said, disclosure is kind of the operative word here. So as long as everything is thrown out there and there's no really kind of misrepresentation or anything like that, then I think both sides are kind of in the clear. And again, it kind of puts the responsibility on the purchaser side to find out a little bit more. And once they have all that information, they can kind of make a decision from there. The next question asks, can you assist elderly or disabled clients with the form?
Wow, you guys are good. I'm gonna tell Michael Chris, he's our technician, to put your emails down. I'm gonna try to sign you guys up for the Forms Committee in 2014, and whenever the Real Estate Commission decides to update this thing again. Sometimes you got to do what you got to do to make a sale. The form does have a warning on page 1. It's the 1, 2, 3, 4, 5, 6 paragraph down. Michael's scrolling to it. Third line up there from the bottom of that paragraph. It says owner and purchasers are solely responsible to consult with their attorneys regarding any disclosure issues. So Article 13 or ethics, you got a duty to tell them to talk to their attorney. When you say assist, I'm thinking you're going to be reading the questions to them, interpreting the questions, interpreting their answers, putting their answers down on paper, explaining things to them. You're getting really close to losing your liability protection, because that would be strong evidence if there was a lawsuit that, you remember we talked about that Chastain versus that, I'm going to use one of the other defendants in here. There was another real estate company in here instead of Hiltonville. It's hard to say. But they talk about, does the realtor got the defense because they didn't know that the answers were false, incomplete, misleading, inaccurate. I think if you're explaining things to these people, I know they might be, hard to see. They might have, they may be blind or have disabled conditions, and you want to help them, and sometimes you might have to make that business decision. But I think you do you're increasing your vulnerability to a lawsuit getting around this court case, this 2009 court case that set precedent for you.
Yeah, I'm kind of along the same ways. You're really kind of treading the line there as far as assisting, whether your client is an elderly person or a disabled person, and kind of going beyond what your responsibility, what your duty as the agent is. Maybe you definitely don't want to get into the meat of the form and kind of go question by question, kind of read it to them again, explain it, kind of discuss, go back and forth, be like, oh, well, what do you want? What do you think I should? What do you think we should go? Like, and anytime you kind of cross that line, you're opening yourself up to that liability. So I think kind of the better approach, and I know every situation is different, and some situations could be extremely difficult, but I think the better approach would be to kind of, again, explain your role as the agent, explain the form as far as the purpose behind it and why it's required, what kind of part it has in the transaction, but then maybe kind of work with them or work for them as far as finding someone else, like a family member or someone that they're closely associated with, that whether they have a caretaker or a legal guardian, someone like that who kind of has their best interest as far as kind of personal wise, and locate that person and kind of talk to them and again kind of explain the difficulty behind it, why the form is required, and allow them to help your client fill it out. That way you're kind of distancing yourself from the transaction and from the actual answers, the questions and answers in the form, but yet you're still trying to help your client. And as long as you know they're kind of represented on their end and still fill out the form, then I think you're good to go. But yeah, definitely try to avoid that situation as much as possible. Sitting down with your client, going question by question, and kind of discussing back and forth and then have the client making the call based on kind of your advice. I think that's kind of a bad approach to it. The next question: what's the best way to check whether permits obtained or not? Whether there are permits obtained or not? I guess that's the question.
I think they're referring to section 515.
Right.
And it talks about violations or do you have, again, as Michael points out, you always want to read what's the question. Their answer says, as owner, do you have actual knowledge of notice concerning the following violations or variances of the following zoning laws, restrictive covenants, building codes, permits, which this question touches on, or other land use restrictions affecting the property? It could be historical buildings or something like that. You know, it's asking actual knowledge. So the seller, if he has actual knowledge of a permit issue, then he could answer yes or no. If he doesn't remember, you're going to refer him to his attorney. And ultimately, I mean, you'd be dealing with government officials trying to find out. And that permit issue is a hotline call. That's the classic. Somebody adds a den to the back of the house, another bedroom, and maybe it's built well, or maybe it's not built so well, but say it's not, they haven't gotten government permission to put it back there. And then post-closing, it's hard to detect because it looks like it belongs to the house. Post-closing, the county calls them up and says, hey, you need to tear that thing down. And obviously that's expensive, and they bought the house thinking they were going to have that living space. And they're going to be, their lawyer's going to be trying to sue you, the seller, the listing brokerage, the buyer's brokerage. And hopefully you've got a defense here where you could say, hey, I didn't have anything to do with filling this thing out. I had no knowledge that the seller put false or misleading information, inaccurate information about the permit. So this is one you want to, we talk about handling stuff with a 10-foot pole. This is one of those issues about permits. You'd say, hey, page 1 of the form talks about, just like we talked about the elderly question earlier, owner and purchasers are solely responsible to consult with their attorneys regarding any disclosure issues. So this one's one that can sting your checkbook. So be careful with permits. Don't give them advice. Refer them to their attorney, and ultimately they'd probably be dealing with government officials.
Yeah, I'm just kind of kind of jumping on what Byron said at the beginning of his answer. I think it is a very kind of important issue, and ultimately a legal issue that could wind up be between the seller and the purchaser. So I mean, again, kind of the question that's being applied to every subsequent question is, do you as the owner have actual knowledge? So whether, as long as they do, maybe they disclose that, check yes, and then kind of explain, and then once the buyer is made aware of that, they're kind of put on notice, and then they can even kind of do their research on their end and find out, what permits or what issues, what kind of government related issues, whether it's, the local government, the county, the state, or maybe even federal, they kind of need to do that on their own, and the parties should do their best and contact their legal advice or consult with their attorney, and if there are any kind of big issues with that, then that's kind of the ideal situation where the parties would do their research and then find out as much as possible and move forward. But yeah, on the property owner side or the seller side, if they have actual knowledge of a problem concerning that permit or any sort of governmental issues, then yeah, they just would need to disclose that, explain it as best as possible, and then the parties can kind of work it out from there. All right. The next question: if a seller wants to sell as is, do they need to complete the seller's disclosure?
Yeah, we talked about earlier about the in the SCR listing agreement, section 8. It puts some duties on sellers. It says the owner warrants that the owner's knowledge there are no material defects hidden or obvious in or on the property which have not been disclosed to broker in writing. It says the owner further warrants that the owner has reviewed and completed a seller's property Disclosure statement is required by South Carolina Code of Laws as amended section 275010 is attached and made part of this agreement. Such information is accurate to the best of the owner's knowledge. So what this question touches on is, hey, I'm making a business decision as a brokerage to take this listing without a seller disclosure, recognizing that it stripped a lot of my liability protections. SCR has an as-is addendum, and in the contract, in the section in the new contract, it's section 16. But there's a similar language in the current residential contract for the buyer and seller. There's two check boxes. Buyer and seller agree that the seller has delivered prior to this contract a condition disclosure statement of the buyer, or the second box, buyer and seller agree that the seller will not complete nor provide a condition disclosure statement to the buyer in accordance with South Carolina Code of Laws. And then when Michael was talking about the exemptions, 2750-30, 13, unlucky 13, between the parties, when the parties agree in writing not to complete a seller disclosure statement. But as a realtor, especially a listing brokerage, you want to avoid that at all costs. So you want to leverage the seller into signing one of those seller disclosure, even on an as-is. And you're not really concerned about how they answer it as long as you know it's not false. As far as yes, no, no representation. I know some attorneys have advised their clients on certain ways to answer it. That's not really, you don't really have a dog in that fight, but I do think you want to try to get a seller disclosure in there, even on the as-is. If you make the decision to strip some of your liability protections, can you do it? Certainly, you would use the as-is addendum to the contract. You could, and then the buyer and the seller would agree on the contract that there's not going to be a seller disclosure. But this is your best liability protection you got out there. This thing's gone up to the Court of Appeals. We got a precedent-setting case to protect you guys. The court did exactly what we wanted them to do with the statute. So can you do it? Yes. Should you do it? That's a business decision. SCR recommends you try to get that seller disclosure in every transaction.
Yeah, I think that's kind of a very well-rounded answer. It kind of covers all your bases. Again, we've had a few questions with this specific issue. Whether if the parties kind of know and acknowledge that they want to move forward with an as-is contract, the seller doesn't want to provide a condition disclosure statement. The buyer accepts that, acknowledges it, and agrees to that. Then yeah, that is an option. Between the two parties, you kind of leave it up to them, and as far as the transaction, they can absolutely move forward with it because both parties agree to it. Now, kind of echoing Byron's sentiments about making a business decision at that point, you kind of want to sit back and think about it and realize what kind of liability that's potentially out there. Again, this form, as long as you give it to your client and the client fills it out, it is a very strong liability shield for you. So we strongly advise that you get it done, that you give it to your client and let them fill it out. We advise that to do that as much as possible for that reason. But if you do all that, you give it your best efforts, you explain everything, and the client still, despite all that, still wants to move forward without completing it, you make it known to the buyer and the buyer's agent how your client stands. They accept it. The parties kind of contract that into it. They want to move forward. The actual transaction and the parties can move forward, absolutely. But you, as the agent, again, are going to have to make a decision on whether you still want to be involved in that and move forward without the condition disclosure. But yeah, it's definitely an option, something that we strongly advise against, though, for the obvious liability reasons. Okay, the next question we have: why not use the term unknown instead of no representation?
It's and actually unknown does show up on the form at one point. The task force added it. It's section 1C, describe water pipes. You got PX, copper, PVC, CPVC, polybutylene, steel, other, and they actually put a / unknown because pipes are something that a lot of times people don't know. I think a lot of these descriptions people are going to know, especially like HVAC. They're going to know if it's central or ductless or heat pump or window unit. Pipes, that's a little bit different story. That's kind of technologically driven. A lot of these, 1, 2, 3 of them are plastic type looking pipes, so it might confuse somebody. But the answer, that's a long answer, but the short answer is in statute. You have to use yes, no, no representation.
Yeah, and I've kind of scrolled up to the front page where those answer explanations are given and kind of what those mean. Again, the yes, no, and no representation. If you want to follow along with me, if a question is answered no representation for any question, the owner is stating that the owner is making no representation regarding the conditions or characteristics of the property, but the owner still may have a duty to disclose information that is known or should have been known. So I think, maybe this is just my kind of personal thoughts on this, but I just think it's a more accurate, more complete answer as opposed to unknown. I know the task force, really wanted to adhere to the statute again and kind of follow along as closely as possible. So that's I'm sure one of the reasons, and just kind of having an unknown, I think it just kind of opens up. It creates more problems than it solves, and no representation does a little bit better job of that, of clarifying again when the owner marks that it just states that they're making no representation as to that question regarding the conditions or characteristics of the property. So, all right. The next question asks, you may have already addressed this question, but in case you didn't, if a listing is expiring and being renewed, do you need to have this new seller disclosure statement to replace the previous one? I think we kind of need to have the effective date in mind. Again, we did kind of address two contrasting questions earlier, and they kind of revolve around the effective date of August 1st. So if again we're kind of harking back to the two previous questions, but if the listing was taken previously prior to August 1st, again you have I'm sure, or hopefully you didn't use the new current version, you have one of the older ones and you have it on file. And if that listing is expiring, and let's say it expires prior to August 1st, and it gets relisted, and you fill out a new disclosure form, you still need to use the older form, either the 2003 or the 2013 January version of the form. But let's say the listing is getting ready to expire, and the effective date of August 1st goes, and then the client wants to relist, and you do that for them. That's where the brand new version, of the form that we've been talking about today, that's when it needs to be used. So I think you just really want to keep that effective date in mind. That's kind of the trigger to whether you use the older form or the brand new form. But yeah, as long as you keep that date in mind and you kind of update it along the way, I think that's the best approach to it. Better explain that. Yeah. Okay. Do you anticipate any changes do you anticipate any changes in the form between now and August 1st? No. I think that's why the process has taken as long as it did. The task force kind of went back and forth, solicited a lot of comments and feedbacks from all agents and real estate professionals from around the state. The final version of the form, I think, as Byron mentioned, was finalized in May. It was presented to the full commission by the task force in the June meeting, and that's when it was approved. And I think it was the same meeting where they set the effective date as August 1st. So because it's been finalized and passed by the full commission, the whole kind of comments and feedback period is over. The form is done. Again, the effective date is August 1st. Moving forward, so yeah, after that date, the new version of the form is used. It's available again on the main Real Estate Commission's website for you to look at and be comfortable with, but not use yet. So yeah, the version that you see, the form that you see, is the final form, and there should be no changes, and we do not anticipate any changes.
Yeah, and Chair Tony Cox even made a comment June 12th, 2013, when they passed this, that they don't intend to look at this thing for a few years. It was 10 years making the initial change in January, and they heard plenty of comment from you guys. So you guys did a great job getting your comments to them. I don't think they want to open this back up to changes for a few years.
Okay. And the next question asks about party wall again. So maybe I can scroll down to that again. I think we're in section 5, and it specifically asks, is that just a common interior wall, or can it be an exterior common wall?
You're on the forms committee, whoever's
yeah,
question.
Yeah. I think again that kind of gets into kind of the specifics of that question. Question 16, what exactly does party wall cover? I mean, the intent behind it, is only, I guess, known to the task force, and then kind of the experience, people on that panel, what that means. I feel like it would cover everything, as long as it's, if it's a common wall, then any sort of issues with that, the seller is going to want to disclose. Again, that whole section discusses, those kinds of encroachments or issues that affect the property, whether it's from an adjacent property next to it or something that's connected. So, I mean, if it's a common wall, whether it's interior or exterior, again, you're kind of delving into a little bit too much, maybe a little unnecessarily, but yeah, I feel like it would cover that, and any issues with a common wall, adjacent real property that's going to affect the actual property, the property that's being the form's being filled out for, then yeah, you just make the necessary disclosure. Again, explain everything that the owner has actual knowledge of, and that'll put that issue to clear.
And section 9, you've got blank. We're never, the Real Estate Commission's never going to be able to imagine every kind of scenario or every kind of issue you guys run up against. So disclosure stops lawsuit. So always disclose and put it in section 9. That's always the same thing.
Yep, and I think we might be giving the same answer to the next question. The question asks, where would an owner disclose the pending construction of a major road in close proximity to the property? For example, the completion of I-526 across Johns and James Island. I guess this question is coming from the lower part of the state, down near the Charleston area. So if the owner knows of some major pending construction or road construction in close proximity to the property, again, as the question asks, if they feel like it's going to affect the property and they have actual knowledge of it, then they can absolutely disclose it in section 9 or in any other additional sheets that they want to. I don't think that maybe that question is addressed somewhere in the form, but I can't remember it specifically. So again, any sort of issue that the property owner wants to disclose and want to get it out there and let the potential purchaser at least aware of it, and then they can kind of do a little bit research on their end to find out exactly all the details. But yeah, just anywhere at the end of the form in section 9 with those spaces or any additional sheets that they want to attach.
Yeah, I think good answer from Michael. Disclosure always stops a lawsuit, but this is a huge debate, and this is really before kind of Michael's time when he came on board here. When they came out with the January 2013 form, this off-site condition issue is difficult to ask questions about because it's subjective. So there was a huge debate, and we kind of alluded to it during the discussion between buyer agents and listing agents. Buyer agents obviously want this kind of information disclosed. Listing agents a little bit scared about some of this stuff. So in the January 2013 form, there were some off-site conditions on there that have been removed on this form. So it was a discussion and a decision by the task force. In the January 2013 form, there's a question, number 21. It said, if you choose to volunteer information about nearby issues that may or may not be in the public record yet, please report here. And there's a lot of uproar from brokerages around the state. They did not like that question. So that question was taken out. There was also a question, number 16, nuisances, noise, odor, smoke, etc., affecting the property. And again, arguably a subjective question. What may be a nuisance? Somebody might like to hear the whine of interstate traffic, puts them to sleep at night. Other people, it might be horrendous and cause them mental distress. So it's subjective. So question 16 on the January form asks about nuisances, and again, there was uproar from brokers around the state. Did not like that subjective question. Felt like it's opened their sellers up to some lawsuits. So they didn't disclose that highway going in. So the task force even looked at maybe we just put a warning on the form saying, hey, buyers, you need to inspect for off-site conditions. That warning was pretty big and bold, but it's been boiled down. If you look at, it's the last page, 5 of 5. Michael's going to scroll to it, that first paragraph. It talks about the disclosure does not limit the obligation of the purchaser to inspect the property and improvements But look at the next sentence. This is where the warning kind of got boiled down into a sentence. It says, purchaser is solely responsible for conducting their own off-site conditions, which is classic, the highway going in, or say you got a beach view, and all of a sudden a high-rise cuts off that view, or those beautiful woods in your backyard get turned into a shopping center. So that's that warning. The buyer is solely responsible for conducting their own off-site conditions and psychologically affected property inspections, because these things are both very subjective. What could be an off-site condition that really bothers somebody might not be a big deal to somebody else. Psychologically affected, that's the classic, you know, is this house haunted, or there was a double murder suicide there? It's just psychologically stigmatized, but not physically stigmatized. And you do that prior to entering a real estate contract. So buyer agents, you need to have a conversation with your buyers, hey, to find out what's important to them. If it's important that they know about highways coming in, or any kind of off-site conditions, you know, traffic, or there's a festival going on the road, certain part of the year, the noise and stuff like that, or there's, you know, some sort of pig farm that has a lot of smells coming off of it. The owner is not responsible for disclosing off-site conditions or psychologically affected conditions. Those were actually removed from the last version based on comments from you guys out there. So that's a little bit before Michael's time, but his answer is correct. To make sure there's no lawsuit, you could always over-disclose, but some listing agents felt like, hey, if we disclose something like that, it's going to put our seller at a disadvantage selling the property. So it's been a debate. There's both sides of the coin. At the end of the day, the task force decided not to insert off-site conditions into the current one.
All right, great. The next question, how much can a realtor tell an owner when the owner is asking questions about not understanding the form or what their answer should be? I assume we are not to answer those kinds of questions and suggest they reread the instructions. That's definitely kind of the stance that we would advise on. Again, any specific questions that you have in regards to the subject, you can call us and ask us about it. But yeah, more than likely, you know, we're really going to advise you to avoid answering those kinds of questions and really kind of discussing it with your client. You know, the fact that you explain the form and kind of direct them to the instructions and you know what their answer choices are and why the form is required. I feel like that should be ideally that should be enough, and the client can kind of take it upon themselves at that point to read the instructions, read the directions and the questions that follow it, and answer accordingly. But we absolutely understand that depending on the situation, they could either ask you for advice or kind of unsure of what to do, and you want to discuss it with them. Really you just really want to avoid that and let them kind of do kind of research on their end, and again kind of consult or advise them to consult a legal expert, an outside attorney, because again, if there are any issues with it down the line, it is going to become a legal issue, hopefully just between the parties, between themselves and you as the agent. If you did your role correctly, then you shouldn't have any involvement in that. I think that's just the best approach moving forward, and you kind of leave the client up to his or her own efforts to best answer the question. So you should really just try to avoid that as much as possible.
Yeah, that's what I would say. And I know it's difficult. You're dealing with these people. They're human beings. But like Michael said, call the legal hotline, 800-233-6381. Contact your broker in charge. Your broker in charge, you want to set a policy about how, because women is managing risk, or hands-on helping somebody. And we've only got one case that's gone to the court of appeals. But in that case, the realtor didn't have a whole lot of contact with the seller as far as filling that form out. And it worked. It worked as the statute that we lobbied for and got passed. It protected the realtor from getting sued. So we don't have a court case that says, hey, if the realtor starts talking about certain type issues, does that negate the liability protection? So the answer is be safe. Don't give this advice, because we know that won't get you sued. But again, you got to make a decision. You're dealing with people as clients and human beings. But I would hotline and call your broker with individual questions on that.
Okay, moving along, the next question asks, can we, or please confirm those owners that are exempt from completing the form and the question has a couple of examples, I guess, from that list. We have the list of or the exemptions in front of us, and we could definitely read that list for you. It's kind of a long list, so if you guys will all want to look up the statute again, it kind of mentions it at the beginning of the form. The statute is 2750 Article 1, and I think that kind of goes into the requirement of the form, what the purpose of the form is and whatnot. But then right below that in section 2750.30, you're going to have the list of exemptions, the property owners who are exempt and are not required by that statute to fill out one of these forms. The classic examples that we've dealt with have been, like bank-owned properties. Banks have done their own kind of lobbying efforts to get themselves removed from that requirement. They are exempt. And then kind of what we touched on earlier, brand new buildings or constructions who have never been occupied, that would be exempt. But the exempt list is very kind of specific, I guess, hopefully. And as long as the client doesn't fall under any of those categories, then again, you are that client is required to fill it out.
Yeah, and because this is a legal issue, Michael's exactly right. You don't want to be somebody giving advice, oh, you're exempt, don't worry about it, because that could get you out of hot water and get them out of water. That's a legal issue, and you go to ethics. Article 13 requires you to refer them to their attorney on if they're exempt or not. If they think they're exempt and it turns out they're not, guess what? They can be sued for actual damages on attorney's fees.
Okay. The next question asks, many investors and second homeowners have little or no actual knowledge about many of the questions on the form. It's been common practice for many of these owners to choose no representation since they truly have no actual knowledge. Many have never even personally seen the properties, or if they have, it was for a very short time. Is it proper to choose no representation? The majority of the questions answering yes or no will be misleading since they truly have no personal knowledge. I think that participant in asking the question has kind of framed the issue ideally. In that case, you're still, as the agent, you're still giving the form out. They're still ready to fill it out. They're not, they don't fall under one of the exemptions. And since they are, honestly filling it out, if they don't have actual knowledge of anything, or since they don't have actual knowledge of anything, they don't want to make any representations by putting yes or no for the questions, then again, you don't really want to get too involved in it and say, oh yeah, you should absolutely just go straight down to representation, you're good to go. They should still kind of seek outside counsel, and if they're after all of your explanations as far as the form, the purpose behind, and they understand, and they at that want to make an informed decision to go to mark no representation for a lot of the questions, then as long as the form is completed, then again, you're kind of shielded from any liability from that, and the property owner it has disclosed or has answered all the questions, and then the potential purchaser can get that, and then they can ask questions about it or kind of back and forth. But yeah, I mean that's why I feel like that's why that answer choice is there, no representation answer choice.
Yeah, I think that's an accurate answer, but danger, Will Robinson. You do not want to be the one telling them to put yes or no representation, because that enables that lawyer to say that you had reason to know it was false, incomplete, or misleading. Because I don't think the General Assembly intended for somebody to know about something and to hide behind no representation. And you may be dealing with an investor that's not being completely honest with you. And all of a sudden, if you told him to answer no representation and he knew about something, that I think telling him how to answer it would enable a lawyer to potentially drag you in and get around this Chastain versus Hilton lawsuit. So to keep your legal protections, do not tell them how to answer this form. Do not tell them to put no representation. Do not tell them yes. Do not tell them to put no. And Michael mentioned it when he was explaining, talk to the attorney, but I just wanted to reemphasize that, because this is the most common question I've gotten on this form. And we recommend you treat this thing with a 10-foot pole. This is your liability shield. And the more you get your hands dirty with this, the more a lawyer can use that against you.
Okay. I think this is our last question. And I want to thank you again for tuning in and asking all these great questions. And hopefully our answers and explanations have clarified some of the some of the common issues that we've seen here at SCR. The question asked on addendum item 10, I think we've seen this question previously. I'm going to scroll back down to it so we can look at it. And our participant's question is this for beaches only or rivers also? And we can all see that the question on the addendum, question 10, asks, is the property or common area structures subject to South Carolina Coastal Zone Management Act?
Yeah, I would say beaches only with a setback line. This is always a good conversation you're having if you're dealing with something that's on the lake or a river. It's always a good time, a trigger to remind buyer agents when they're looking at this, hey, you want to get it inspected, you want to get it surveyed. If there's an isolated wetland, which really isn't under this act, but it's an issue a buyer's going to want to know about it, good way to trigger you to think about that. We've actually moved, in the new contract, we moved this onto the Form 391 addendum because it is confusing. It does deal with a beach, so not a lot of properties are impacted. When it was in the body of our contract, it was confusing a lot of people, so we've moved that to the Form 391, that addendum page with you check boxes for the different areas.
Yeah, just to add a bit to that, I think the specific Coastal Zone Management Act does refer to again the coastal areas of our state down near the beaches. So it probably doesn't affect any rivers or streams, lakes, those kinds of situations, more inland situations. But I think there's a question previously on the form that may touch on that. I think it's in perhaps in yeah, exactly. In section 5, this question, we also looked at these specific questions earlier regarding flood hazards, wetlands, or flood hazard designations affecting the property, and again, flood insurance covering the property. So that's kind of an exhaustive kind of topic, and if it's if it's a river situation or a lake situation, that I think those questions again 22 and 23 in section 5 address those. So there's an opportunity for the property owner to answer and to explain any other answers if they have actual knowledge or notice concerning the following. So you can definitely not direct, but kind of acknowledge that those are separate issues. I guess what I'm trying to say, beaches, coastal area versus more inland waterways, they're kind of separate issues, and they're both addressed in the form. So you don't want to kind of mix those up.
Yeah, I just want to say thanks to Sharon DeLea. She did the layout for LLR. She's a staffer here at SCR, and she does all your layout stuff for your website with Michael Christ and the weekly report and the website and our annual conference. We got a couple of things here. You want to read those?
Yeah, sure. I just also want to thank everyone who worked on the form, everyone that Byron mentioned earlier, our staff here who did a great job in formatting and doing the layout for the form. I want to thank all of you for tuning in and asking all those the great questions that we answered. Hopefully, this has been helpful as far as trying to work with the new form. Again, that the effective date is August 1st. So certainly don't use the form prior to that, but after that, only this current form, the form that we just talked about and discussed, will be legally accepted. Last bits of info for you. Again, if you have any legal questions, call us at the legal hotline. It's 800-233-6381. Reminder, we have our annual conference coming up in September. A lot of great speakers, a lot of great events, so you don't want to miss that. Register for our annual conference at screaltors.org/AC13. Again, that's for our annual conference coming up in September down in Charleston. And this webinar will be recorded and archived at our website. Again, it's screaltors.org/webinar. So if you missed any issues, want to go back and hear any of the question and answer portion, or if you have a colleague or people in your office who, for whatever reason, couldn't be with us today and are interested in staying up to date with the form, tell them to tune in. It will be on our website again. And I think that's it. I want to thank you again, and call us if you have any questions. Thanks.